Israel and Hamas agreed to the first phase of a ceasefire as part of US President Donald Trump's 20-point quote-unquote peace plan for Gaza. While Trump has called it a historic breakthrough, UN experts and legal scholars warn that the plan may entrench impunity and sidestep key obligations under international law.
Everything else that follows in the Trump plan has been fully critiqued. The centrality of the right of self-determination, which I touched on earlier, which is in all of those post-Second World War treaties as a central right. The Palestinians have to have that front and center. Forget front and center. It's not even an object, a plan, a part of the Trump plan. It doesn't feature in the Trump plan at all, let alone being front and center. The starting point has to be now the right of the Palestinians to exercise self-determination, and it's just nowhere there. Across the world, certainly of a legal critique or a political critique, do not come from an anti-Semitic standpoint and are not expressed anti-Semitically, but are described wrongly by those who are die-hard supporters of Israel in order to undermine and to seek to shut down that criticism. They are labeled anti-Semitic, and we need to be extremely careful as we go forward. We are bridged too far to ignore a ruling of the International Court of Justice that Israel has committed genocide, but only time will tell, and certainly how that crisis is resolved, the crisis we're in at the moment, and that will continue, and maybe there'll be peaks and troughs. My understanding of Zionism, my understanding of the need to vindicate the rights of people who have had fundamental rights withheld from them, is partly what does shape my thinking about, what is the best use of my time, my efforts as a lawyer.
Hello and welcome to another episode of Gaza Stories. I am Muneef Khan. My guest today is Daniel Machover, solicitor, co-founder of Lawyers for Palestinian Human Rights, and head of civil litigation at Hickman and Rowe Solicitors in London. For decades now, he has worked at the intersection of law and human rights, challenging abuses of state power in the UK and abroad. It has now been 2 years since Israel launched its assault on Gaza. Last month, the United Nations Commission of Inquiry concluded that Israel is committing genocide in Gaza, citing the mass killings of civilians and deliberate destruction of conditions essential to life. Just a week ago, Israel and Hamas agreed to the first phase of a ceasefire as part of US President Donald Trump's 20-point quote-unquote peace plan for Gaza. The agreement includes a halt to fighting, a hostage and prisoner exchanges, and a partial Israeli troop withdrawal. While Trump has called it a historic breakthrough, UN experts and legal scholars warn that the plan may entrench impunity and sidestep key obligations under international law. Against that backdrop, a deeper question emerges. When international law is applied selectively, invoked in some conflicts and ignored in others, what does that do to its credibility? Daniel, let's start there. When Russia invaded Ukraine, for instance, Western governments immediately invoked international law. Yet with Gaza, those same governments continue to arm Israel and endorse political solutions that many experts say violated. And this persists despite ICJ's order, the UN Commission of Inquiry's findings. Can you describe the eroding credibility of Western governments and that of international legal order today?
Yes, look, I think, Muneef, we need to step back, not at the same time as not sort of ducking your question, because we face a very specific crisis now that you've well described. But there's inherent problems with the international legal order, which is built in to a kind of post World War II settlement, even while the pressures of emerging nations and the primacy of the right of self-determination, as reflected in all the post-World War II key international treaties. Often Article 1 is of those treaties emphasizes the centrality of self-determination of those rights. So, but pulling away from that was the one of the centers of power in terms of the international legal order, apart from individual nation states, which we have a particular problem with at the moment, is that the most important enforcement body of the international legal order under the UN Charter is the UN Security Council. We have five veto-holding members: Britain, France, China, Russia, and the United States of America. And every time we have either a tension between those, or in fact a consensus going the wrong way amongst those five, but it just takes one to be rogue on key international issues, we have a gap and a real problem. There was a real moment in the kind of fall of Soviet Russia in the 1990s, where there was a flourishing that had happened after the Second World War of really important instruments. That the fact the UN Security Council had a consensus on creating ad hoc international tribunals in relation to the conflict in the former Yugoslavia, the Rwanda Tribunal. These were all Security Council initiatives. And then on the back of that, international consensus finally to create an international criminal court with the 1998 Rome Statute. So there was a moment in time in the 1990s which has in a way created a reasonable expectation that we were entering into a new era, international or legal order, that we were going to get some coherence, some sticking to basic standards. But there was an inherent problem, both in relation to, as I said, the enforcement bodies, but also in relation to the law itself. There are some real problems with some of the treaties which needed the most progressive interpretation in some of the key courts. That hasn't always happened. And as I say, there is a tension in the post Second World War consensus in really breaking away from colonialism, breaking away from these central power bases. And now we face those. So jumping to your question, in the major contradictions that we have, whereby certain Western governments were clear on Russia's actions in Ukraine and absolutely evading the same legal analysis and legal consequences in relation to Israel, and that where there are bodies that are trying to do their job, UN special rapporteurs, the International Criminal Court in relation to the issue of arrest warrants, there's a massive kickback by those governments where they're straining against the logic of what the legal requirements are and failing to adhere to those standards. And it's to directly answer your question, it's bringing to the fore the crisis points that always were, the tension points that always were in whether or not we can have the weaker states, weaker populations, civilians subject to military action, whether from their own governments or from foreign governments, and foreign rule can really rely on the international legal order to come to its help. Now, if we go to the extreme of that, then we are encouraging, we are making everyone learn the lessons of Israel, which is you have enough of a powerful ally or a way of blocking the rights of people to access to justice, you can do what you want. And then might is right. And as our friend Raji Sourani, for the director of the Palestinian Center for Human Rights, has said many times, we're entering into the era of the rule of the jungle, not the rule of law. And that's the crisis that we are facing. That we are facing it. It's exacerbated by now the Trump deal on Gaza. This is yet another step in completely the wrong direction. Of course, everyone welcomes the ceasefire, the release of the Israeli hostages. Those were not in compliance with any way basis of international law to take hostages in this way. Equally and very significantly, the number of Palestinians that have just been ghosted away from Gaza during these last 2 years, many of whom remain without access to lawyers, without access to the ICRC, as far as I understand it. And certainly we now have evidence of their ill treatment and the return of Palestinian bodies that should be front page news across the world. But that's been revealed by the positive aspects of a ceasefire. That's obviously a step in the right direction. But everything else that follows in the Trump plan has been fully critiqued I could take up more time. I'm conscious that I've already given you a long answer, but just we can come onto it. I can summarize it if you want me to, but the the centrality of the right of self-determination, which I touched on earlier, which is in all of those post-Second World War treaties as a central right, the Palestinians have to have that front and center. And it's not even, forget front and center. It's not even an object, a plan, a part of the Trump plan. It doesn't feature in the Trump plan at all, let alone being front and center. As I say, I could critique it much more broadly, but the starting point has to be now the
And
right of the Palestinians to exercise self-determination, and it's just nowhere there.
And that does bring me to my second question, and this has more to do with the Genocide Convention. The
Yeah,
convention obliges all states to prevent genocide. And in
yeah,
September this year, the UN Commission of Inquiry found that Israel is actively committing genocide in Gaza. I may also say that I had the opportunity of interviewing the chair of the commission, Navi Pillay, who also commented on the deal, saying that patched up peace is only going to fall apart, to summarize it in
yeah.
shorter terms. However, arms transfers from the UK, US, and its allies continue, while governments even endorse Trump's heavily criticized 20-point plan. So, can you tell us some of the key treaties and provisions in international law that are exploited by these states to enjoy immunity from accountability?
Yes, well, the starting point is that the law is, in my view, very clear. First of all, the right to self-determination is a peremptory norm, a peremptory right. The right not to be genocided is a peremptory right. There are duties which are called erga omnes duties, which are duties on all states to both facilitate self-determination and to prevent genocide. In relation to the specific issue on genocide, we have the government's position articulated many times, but most recently, really, and it was articulated during litigation brought by Al-Haq regarding the arms sales to Israel in the judgment earlier this year. But it was stated quite recently by David Lammy just before he ceased being our foreign secretary in a letter that's been published, a letter of the 1st of September addressed to an MP in this country, where he basically said again, we don't have enough evidence of the intent to commit genocide in relation to the index events that have occurred in Gaza, and that just denies the both. He has elevated some kind of very special test on intent. It's not as extreme the test as he characterized it in his letter. It's just not right. It's not a correct statement of law on the intent question. But he also said, and this is the central parting of ways of the government with all other, I would say, serious legal and analysts and in my view will eventually be proved right, but far too late for it to have the meaning it should do, which is the duty to prevent doesn't arise when we haven't had a finding. That's just so we need a judicial finding. We need a finding somewhere in some court that says it's genocide. Well, we know that the International Court of Justice is going to take at least 3 more years to get to a position where it gives a judgment. With the clue is in the actual title of the convention and then in the provisions that relate to it. But the title of the is the UN Convention on the Prevention and Punishment of the Crime of Genocide. How are we going to prevent something if we're only going to act on that duty once there's been a judicial determination that it's occurred? It's just obviously logically and legally incoherent. So what we know is that the duty arises, I'm quoting in effect from case law, when the state in question learns or should normally have learned of the existence of a serious risk of genocide. Now, the latest that could arise on all credible legal scholars is when the International Court of Justice, in its first provisional measures ruling of last year, January of 2024, the very latest, and in my view, far earlier, given all the commentaries that had happened during the second half of October and November. But let's take it for now that when the court determined that there was a plausible risk that the rights of the Palestinians not to be genocided arose such that the court had the duty of or their decision to actually apply provisional measures, which was the legal test it had to apply to make a provisional measures order, had been triggered. There was sufficient evidence for them to be concerned that the Palestinians were under that form of risk of their rights not to be genocided. That was the plausible risk. That amounts, in effect, in shorthand, to a plausible risk of genocide. It's not exactly what they said, but it's completely reasonable for others to sort of summarize it that way. And most importantly, that must pass the threshold of the risk. So once the ICJ applies that legal test to whether it should um, issue provisional measures, and did so again two further times in 2024, and none of which has been fully complied with by Israel, even as we sit here with the ceasefire. Um, those those arguments just don't hold water. So I hope I've sufficiently explained it. So
Yeah.
where we get beyond that, of course, is once that risk threshold has been passed, and once you fail to do that and fail to prevent, if you then not only don't take effective measures to prevent the genocide, but actually are feeding into it, you're arming Israel post that period. So it's worse than not taking action. What they've actually done is made it more possible for the genocide to continue. So, I mean, if we were in a position where there was no assistance, there was nothing that could be done, no levers that could be pulled at all, which I don't accept for one moment, we might be in a different position. But we move from a position of failure to comply with the duty to prevent to potential complicity. And then there's evidence of positive complicity by selling more arms than the F-35 carve out from this, the decision that was finally made by the UK government in September 2024 to suspend some key licenses. So they moved forward. There was a move forward under the Labour government, but was it sufficient to to really head off arguments that they are not only gone beyond the point of failing to prevent, but they've actually been complicit? And that's where we sit at the moment. And it's difficult to go further again in the time available in critiquing it. I hope I've summarized it
Yeah.
uh,
And but I also want to
sufficiently
move.
for now.
Yes, I also wanted to move into your personal roots. Your father,
Okay.
Professor Moshe Machover, he co-founded the Israeli socialist group Matzpen, and both your parents were anti-Zionist Israelis, if I may say.
Yeah.
And how did that environment shape your path as a lawyer seeking accountability? Because I did find this very interesting when I was going about my research on you.
Well, thank you. I mean, I think that the the position has always been clear, and I think it's really important when I answer this to say that as a domestic human rights lawyer, but also as someone from that background, that his sort of personal background, I don't want to, in answering your question, to go away from the fact that I've always been interested in, and I want to keep in the center of where we're talking about, trying to vindicate the rights of those uh, who are not receiving justice, who have not got their social rights. And so the centrality for me is that the power for the Palestinians and the Palestinian friends that my parents had and that I have, the key to me for them is seeing justice for Palestinians. And the key to me for the human rights work I do is to try to assist clients to get access to justice where they are vulnerable or have been marginalized, and their families and been denied and locked out of justice when there's been death at the hands of the state. And I think that comes from actually a Jewish ethos in relation to my heritage. Although we grew up as secular Jews, there was something in the background of both my parents, especially my father, who had his own sort of um, religious thinking, and I think that um, when they understood that um, Zionism was inherently racist and the inherently racist wrong response to the racism that Jews had experienced over a horribly long time, but which obviously reached obscene and unheard of previously uh, stage of horror in the Holocaust, in the Second World War, that looking at all of that history, looking at all of those um, collective breaches of human rights, it was essential to look at humanity, the humanity of individuals, and to consider what is the appropriate response to racism. Do we believe in a progressive world that we can get at the root of racism, that we can, however long it takes, that our project is not to fundamentally sort of accept the tenets of racism, that there are certain peoples that can't live together, that should have their own individual homelands, white supremacist ideas, Jewish supremacist ideas, Sikh supremacist ideas, Hindu supremacist ideas, ideas that there has to be, for example, Muslim states and states where there's an inherent difference between the rights of Muslims in that state and non-Muslims in that state. All of these approaches to um, exclusivity, to um, go in that direction is just fundamentally wrong. And not only is it fundamentally wrong in principle, but it will involve, in the case of Israel, a settler colonial project. Because if you marry the objective of Jewish exclusivity with um, coming to a land where there was peoples that wished to live across religion and across. So we had Palestinian Jews, Palestinian Christians, Palestinian Muslims living together in Palestine, coming into that space and saying, no, the Palestinian Jews belong to us because we're the Jews, and we are going to bring more Jews to settle. And with an ideology, fine if Jews wanted to come to Palestine and they were in the early period, they were welcomed. But and there weren't those kind of inherent tensions that had been in Europe because they didn't arrive into a place which was steeped in anti-Semitism at that stage, um, or any stage since. The opposition to Jewish immigration into Palestine grew in Palestine when they realized that this was a settler colonial project. So in a roundabout way, I hope I've answered your question, but my understanding of Zionism, my understanding of the need to vindicate the rights of people who have had fundamental rights withheld from them is partly what does shape my thinking about, what is the best use of my time, my efforts as a lawyer. What should I be doing? And I don't want to make it sound um, like I'm some kind of martyr because it's nothing to do with that. It's not a question of martyrdom. It's just a question of how can I be most effective? And that's a kind of question I try to ask myself every day. I'm sure we all do in our jobs and roles. But one of the measures of that is can I make progress on vindicating people's rights, especially where they're marginalized.
And since you did touch up upon Zionism, and I wanted to ask this question for audiences that view this from afar. Can you describe the difference between Judaism and Zionism? I know it's a naive question, but for a lot of audiences, the difference, the
Sure.
relations.
Well, I'll try. I think there are three sort of conceptual points, and you missed out one of them. The religion, Judaism, the ethno-religious um, identity of being Jewish, and Zionism. And they can be conflated and confused, and it creates a lot of problems. Um, Judaism is the religion of Jewish people, where they are devout and follow the religious rules. There are various brands of Judaism. There's the liberal brand of Judaism, which is denied by the Orthodox Judaism sometimes. So there are tensions within, and that occurs in lots of religions, whereby adherents to, say, Christianity have we've got Catholicism and Protestantism and other forms, and within Islam, of course, we have Sunni and Shia Muslims, etc., etc. So, it's not unusual. So, there are those religious Jews. There is separately the ethnic uh, definition of Jewishness, which is someone in your heritage was a religious Jew or adhered to Judaism. and through the matrilineal line, you're born into being Jewish. Many people who describe themselves as Jewish and who are Jewish through that ethnicity are non-religious. They don't adhere to Judaism day to day. They may, in certain diaspora uh, populations and in Israel itself, seek to play work through their Jewish identity or be inherent in their Jewish identity to, for example, have a Friday night meal, a Shabbat meal. For example, they may, on a particularly important holy day like Yom Kippur, the Day of Atonement, go to synagogue. Many won't. Many will think quietly at home about the Day of Atonement without necessarily going to synagogue. So again, a range of people about how they identify as Jewish, um, and many secular Jews across the globe. So who may never step into a synagogue for a religious, even if Jewish weddings occur, or even bar mitzvah is recognized. Is done in a variety of different ways in a variety of different engagements with having a Jewish identity. And then there's Zionism. Now, Zionism is a settler colonial project, which begins from the premise, as I said earlier, that you can't really fundamentally fight against anti-Jewish sentiment. Rather, you need to collect together as Jews and build a nation, and build a nation in a settler colonial way, and the project that was in Palestine. And those are totally different. That's a totally different um, way of being Jewish, because there are people who are, and Jews across the world may not agree with Zionism, whether they're religious Jews or secular Jews. And many religious Jews regard Israel as an affront to Judaism because it puts into an earthly form um, a state which is antithetical to the Jewish religion. So there are religious Jews, very devout religious Jews, who regard Zionism as entirely wrong and against Judaism. So we have a movement of Jews who say, well, the response to racism is we need to create a state for all Jews in the world. We will seek to represent all Jews in the world, and we will try to build a land, and in the most extreme form of Zionism, a land which creates an exclusively Jewish state, or certainly exclusively Jewish rights, in a whole area of Palestine that goes beyond and, in fact, includes what they would call Transjordan. And we have maps from some of the early Zionists which include within an Israeli state lands well beyond the lands that Israel even currently occupies, let alone the 1949 armistice lines and what happened in 1967, ambitions beyond that. So these are three totally different things that interact with each other in complex ways. I'm not saying it isn't complicated, that interaction, but they must be carefully described and analyzed and looked at differently. And one of the roles that Israel has sought to fulfill, the Israeli state, consecutive Israeli governments, and various laws within Israel, like the law of return, but also certain other laws, is to conflate all three together and say to be anti-Israeli is potentially to be against Jewish religious rights and against Jews as a collective. So that has been the danger. Now, of course, it is not to say that somebody who criticizes Israel and does so in a way that is anti-Semitic is not impossible. You can, of course, be criticizing Israel from an anti-Semitic standpoint. But most of the criticisms across the world, certainly of a legal critique um, or a political critique, do not come from an anti-Semitic standpoint and are not expressed anti-Semitically, but are described wrongly by those who are die-hard supporters of Israel in order to undermine and to seek to shut down that criticism, they are labeled anti-Semitic, and we need to be extremely careful as we go forward to identify when that is happening and how wrong it is, and seek. And I think when Israel went on the front foot in the early 2000s to try to label all critiques of Israeli conduct and how it plays out in the world as any critique as being anti-Semitic has not been sufficiently thought through as to how to address all of that. Partly because there were so many issues that needed to be explained and put forward that being ready for that was difficult. So I know I've given you a very long answer, but can I just say the International Holocaust from the IHRA definition of anti-Semitism, there isn't a problem with the definition in itself. The examples given there have not been sufficiently understood by a lot of people who do understand Israel-Palestine, but they fail to understand how important it was to make clear that that working definition, by the way, was never supposed to be a kind of definition to be legally applied, and that the examples of it needed individual critique. There are alternative, like the Jerusalem Declaration and others, and other universities and institutions have sought to write and enforce completely legitimate policies to address anti-Semitism, and we need to be part of that battle. All of us need to be part of that battle because there cannot be a targeting of Jews as Jews in any country that helps to create new anti-Semitism in any country. That cannot be tolerated. We as anti-racists, as people who want to see Palestinian self-determination, have to stand up against that and be part of a coalition to address it. But at the same time, not for a moment falling into the separate trap of being silenced or being stopped from giving legitimate criticism to both Israeli policies and Zionism as a colonial project.
And coming back to Israel itself, and I would say this if or when the ICJ ultimately rules that Israel has committed genocide in Gaza, it is very likely, and I don't say this lightly, but this is very likely that the enforcement of those rulings will be blocked by Israel's allies. What does this deadlock mean for the future of the Genocide Convention? And I say this because in the past, we've seen instances of Israel's allies, playing in and helping them out in dire situations. So, yes, coming back to my question, what does this mean? What does this deadlock mean for the future of the Genocide Convention?
Well, it's this I can give a hopefully short answer to. It's the answer I gave earlier, where the tensions that I mentioned right at the beginning are coming right to the fore, and that will we will have to see whether or not um, the modern era of public international law can really survive this amount of dissonance, this amount of non-compliance. It was always inherent, as I said, there was always been this inherent tension and a real problem in public international law and the enforcement of it and the adherence to it. But if we're going to the stage where conventions are just generally going to be breached by, and these peremptory norms are going to be somehow relegated to the a dustbin of legal history, then we face an existential problem as nations, as minorities, as I said, civilians caught both in relation to occupations by foreign powers or where their self-determination rights are being quelled, to to internal strife, where we will never see states thinking that they can be that the law is going to be enforced against them, and that if you have the backing of a powerful state, you can just do what you want. And the dangers inherent in that are, I hope, just obvious for everyone to see. So I hope, that at some point, states that understand the long-term consequences of all of that and that don't want to see that happen can somehow come together, turn around, and the Hague group of states and other states, states of the global south that really understand what this could mean for them, um, can hopefully shift the thinking of some of the Western governments. So I mean, I do think there will be a split even in the West, because I think some states will understand that and will understand that they can't, that it'll be a bridge too far to ignore a ruling of the International Court of Justice that Israel has committed genocide. But only time will tell, and certainly how that crisis is resolved, the crisis we're in at the moment, and that will continue, and maybe there'll be peaks and troughs, but one of the troughs will be um, a ruling of the kind you suggest.
But if I may add, there is speculation that Gaza could be a turning point. You talked about the split in the West, and I did want to say that there is a speculation that Gaza could be a turning point, potentially forcing landmark reforms in international law or causing its collapse. How do you
Yes.
perceive this situation?
Well, I think you described it perfectly, and I don't think I can predict it. I think, as I described earlier, there are inherent tensions. How are they going to be resolved? Are states like the Hague Group of States, which seek to see um, coherent implementation of international law, are they going to be able to use, for example, some of the powers in the General Assembly to create change? What is the Trump plan versus moves in the General Assembly to have a Uniting for Peace resolution? Are we going to see such pressure on the Trump plan that the right of self-determination does actually get in there and become front and center? All of these are tests that are coming up. But if the Trump plan is implemented, as it currently stands, to the extent that it has any coherence, then that this is a disaster for the Palestinians, a disaster for international law, a disaster for the region in the long term, both in the short term, medium, and long term. There's nothing that's appropriate or right about the future implementation of the Trump plan beyond the need to stop um, the scale of Israeli assaults on Gaza. And by the way, we know it hasn't finished because there are thankfully fewer daily human rights violations, IHL violations, but we still don't have full humanitarian aid going in. We still have daily deaths, especially where any Palestinian goes anywhere near about 50, well, almost 60% of Gaza, which is still occupied by Israeli troops. Um, the, the deaths of civilians every day going anywhere near to that zone where Israel continues to occupy Gaza. So,
Um,
there we are.
you did bring that point up, and I mean, this does bring me to my final two questions. I know that we are constrained by time, and Israel's system has been, you describe it as apartheid, but
Yes.
when the world assigned that label in South Africa's case, even as evidence mounts, what prevents the global community from applying it to Israel? Because growing up, even I was taught in my history books and so on, but I see this reluctance from the global community to
Yeah.
apply this in Israel's case.
Yes, well, first of all, Palestinian civil society groups had argued for decades. So I just want to say that we need to acknowledge that it's taken a long time for the international human rights community to catch up with the Palestinian sentiment and analysis. But finally, in the 2 decades that preceded the beginning of the onslaught on Gaza, we had a sequence of international law expert bodies, Human Rights Watch, Amnesty International, Israeli human rights organizations such as Beit Tselem, understanding that when you have a settler colonial project which separates out national rights of Israeli Jews from non-Israeli Jews and creates a systematic racial divide, you have an apartheid system. And the Brussels Tribunal on Palestine was one of those movements and in 2010, there was a Cape Town session of the Russell Tribunal on Palestine, which built on Palestinian analysis that had happened, and as I say, was a stepping stone to the international organization. So what we have is the legal definition is met because we have a distinct racial or ethnic group. We have an institutionalized regime of systematic domination of one group, by one group over another, and we have inhuman acts that are committed in that context. Now, with the inhuman acts, we many have documented the laws in Israel that separate rights from Israeli Jews to uh, non-Israeli Jews, and then we have beyond that the occupation and how that treats non-Israeli Jews who are settlers in the occupied territories completely different under a completely different legal system. And so what we have are a series of laws within Israel that have created an apartheid system. And you rightly say that when that was identified, and of course, the legal definition of apartheid doesn't mean that you have to have a form of South African apartheid in every country where apartheid is found. That's been a misunderstanding and one again that the pro-Israel lobby has sought to put forward wrongly, saying, well, it's not like South Africa, but it is exactly the definition of apartheid in the Convention Against Apartheid. And it's been analysed in that way. And it should have led, like many other movements calling for Palestinian right of self-determination to be put front and center of policies, to a form of boycott, divestment, and sanctions. But actually, now we have on top of that, and there was always a risk within a settler colonial project that it could lead from apartheid to genocide. And that is what we are seeing. We are seeing attacks, particularly on the Palestinians in Gaza, which do meet the legal test of genocide. And the intent has been expressed. We touched on the nature of the intent. There is unusually strong evidence in this case of alleged genocide of the intent to destroy in part the civilian population of Gaza.
And this
So
does bring
that should
pause.
have led,
Yes.
the apartheid regime analysis should have led to boycott, divestment, and sanctions as it did with South African apartheid. But now we have, on top of the many decades in which the legal definition of apartheid has been met, in my view, unarguably, the legal violation of the right not to be genocided is happening. And that creates a duty. So a series of duties over the years were there and have been there and are now fully articulated in the International Court of Justice's advisory opinion of July 2024. So we have everybody can see what the legal violations are and what duties they give rise to. There's no mystery about any of that. So the question is, when are states going to live up to their legal obligations? And that's a question we need to put to our governments every day. That's a question civil society organizations are seek to put to their governments, and not to be distracted by any other arguments, or any other Trump plans or attacks on people who advocate for BDS to be accused of anti-Semitism. These are plain and simple legal obligations on our states.
And this does bring me to my final question, and this has a lot to do with the global South. There is deep despair in the global South at the hypocrisy in the international system. Given that justice is often delayed, what avenues of accountability still hold promise? And if you had to point to mechanisms to support right now, what would they be?
There'd be all the support that I mentioned for BDS and for pushing governments to comply with that. And look, huge amount of work is being done across Europe and across the globe. Support the Hague Group initiative. support individual initiatives in each country to ensure that, for example, nobody can book a holiday in the occupied territories, assisting the occupation of the West Bank. Lobby your government daily to comply with its duty to prevent genocide. Support legal action where it occurs across the world. Support initiatives to bring to light um, investments that shouldn't be happening through pensions in any Israeli corporates or in any way. For example, all initiatives to stop supermarkets selling products coming from Israeli settlements. All of these initiatives across the globe will have some impact. And cumulatively, you can see that um, in due course, if there is enough of this pressure, and of course the ideal is to create states actually implementing coherent boycott and divestment. But each action that creates more isolation for Israel brings home to Israelis that there are consequences for the actions of their government. There are consequences for a Zionist colonial project that mean that they will need to think about whether they continue to breach international law. So all of these small actions can lead cumulatively to change. The stronger those actions, the more we can change the policies of states, obviously, the more that impact will be felt on Israel. But without those smaller actions daily, we can't see kind of people power having the impact on government policies that we need. So that's what I would say. And while uh, across the globe that continues to happen and increases, that increases our chances of seeing some kind of uh, real change happening. And without that, certainly we won't get change.
Daniel Machover, I really appreciate you joining us. Thank you for taking out the time, and I hope to stay in touch with you. Thank you.